Major breaking news. The United States Supreme Court has just entered an order in the case of Rush versus the United States, directing the Donald Trump Department of Justice to take positions involving our Second Amendment rights in a major case involving whether or not short barrel rifles are protected arms under the Second Amendment. Let me break down this case for you and what I think the Department of Justice should do when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so we have a major deal here at the United States Supreme Court. An NRA-related case arising from a criminal conviction of an individual, Mr. Rush here, who is criminally convicted of, among other things, possessing a short barrel rifle that had not been registered and otherwise no tax had been paid on this short barrel rifle under the National Firearms Act. So this individual, Mr. Rush, was convicted and sentenced to 30 months in prison, subject to his ability to argue the Second Amendment was violated by virtue of the National Firearms Act as applied to him. This case is now before the United States Supreme Court, and the question presented is whether the Second Amendment secures the right to possess unregistered short barrel rifles that are in common use for lawful purposes. That is the question presented. Here is specifically what the argument is by the National Rifle Association, who's on this brief in support of Mr. Rush's appeal to the United States Supreme Court. Federal law requires the registration and taxation of any rifle having a barrel shorter than 16 inches, a violation of which is punishable by up to 10 years imprisonment and a $250,000 fine. This case is a Second Amendment challenge to that requirement. Lower courts are unsure how to adjudicate challenges to restrictions on specific categories of arms and have thus adopted a variety of different and often conflicting approaches, many of which are inconsistent with the Supreme Court's precedents. This confusion is most pronounced in the Seventh Circuit Court of Appeals, which has issued opinions inconsistent not only with the Supreme Court's precedents and the decisions in other circuits, but also with its own precedents. Now, of course, we know that the lower courts that have been ruling on these so-called arms ban cases are, generally speaking, absolutely terrible courts. At least the majority of them are. If you look at who these courts are that have thrown our Second Amendment rights under the bus, they're the usual suspects, right? You know them off the top of your head at this point if you've been following the Four Boxes Diner. It's the First Circuit Court of Appeals out of Boston, terrible court. The Seventh Circuit Court of Appeals out of Chicago, a terrible court led by Frank Easterbrook, a total disappointment to the conservative movement. Awful judge, very bitter they didn't make the Supreme Court. And that's the Seventh Circuit, no good on guns, no good on the Second Amendment. The Fourth Circuit Court of Appeals, another bitter individual, the elderly Harvey Wilkinson on that Fourth Circuit Court of Appeals, again, terrible on guns. You've seen his questions at oral argument where he literally talked about when he was in the National Guard during Vietnam, he was able to, cut bodies in half effectively with machine guns, all of which is absurd. And these are the lower courts, including the D.C. Court of Appeals, the Deep State D.C. Court of Appeals, all of which, of course, in terms of the majority opinions, there are some dissents in these places, but in the terms of the majority of these courts, terrible on the Second Amendment rights, and we know that they're actively trying to undercut the Second Amendment, and they clearly are playing dumb as if they can't understand Supreme Court precedent, which is crystal clear. Nevertheless, these precedents are out there now, and it is fair and correct that the U.S. Supreme Court needs to take one of these assault weapon cases, quote-unquote assault weapon cases, magazine cases, AR-15 man cases, or short barrel rifle case. And of course, in this particular case of Rush, the question presented is, are short barrel rifles protected by the Second Amendment? Now, the correct answer is undeniably yes, they are. So the question is going to be whether or not this particular criminal case involving Jamon Rush is the vehicle that the U.S. Supreme Court is going to want to take to deal with some of these issues involving the protection of particular arms that are in common use. And my guess is they probably don't want to do that. But there is breaking news today, which is that the NRA-related case, they filed this petition for cert to the U.S. Supreme Court in this case of Rush. And it turns out the U.S. Supreme Court today just entered an order directed to the Trump administration, to the United States Department of Justice, to put in some sort of a response articulating where the Department of Justice stands on these particular issues presented in this case, and they should do so by and they must do so by September 2nd, 2025. Obviously, at least one of the Supreme Court justices is interested in hearing what the United States Department of Justice has to say on effectively what is an arms ban case, what arms are protected under the Second Amendment. So this is huge breaking news because, as you know, it was just a couple months ago that the Supreme Court denied cert in that Snopes case out of the United States Supreme Court for the Fourth Circuit out of Maryland, dealing with an AR-15 ban case. But in the concurrence in the denial of cert, Justice Brett Kavanaugh specifically said that he expects to take an AR-15 case in the next term or two to finally resolve that. And I suspect it will be resolved very favorably to the Second Amendment. But here's an example of a criminal case that has kind of jumped in front of a civilian a civilian civil AR-15 case. And the question is, what will the Supreme Court do? They obviously have shown some interest in this, because if they had no interest in this, they would not ask the U.S. Department of Justice to put in a brief by September 2nd addressing these questions. So with that said, let's just talk about some of the questions presented in this case. If you think about the question presented, there's really kind of three issues here. Whether the Second Amendment secures the right to possess unregistered short barrel rifles that are in common use for lawful purposes. Let's just start textually. Well, we understand, and this is not that hard, but the anti-gun courts, of course, play stupid and pretend they're not smart enough to understand what the Supreme Court means, but we know they're just playing games. They're not actually that dumb, in my view. They know what they're doing. They're just trying to do whatever they can to throw sand in the gears to screw up the Second Amendment jurisprudence in America. So they play dumb as to whether or not short barrel rifles are arms textually under the Second Amendment's right of the people to keep and bear arms shall not be infringed. Obviously, any moron can figure out that a rifle is a firearm and that firearms, at a minimum, among other things, are clearly arms textually. What else could arms be other than guns, firearms you hold in your hands, and thus they're bearable arms other than, for example, basic rifles. Now, you can debate whether or not a short barrel rifle is protected. We'll get to that in a second, but textually there cannot be any debate that a short barrel rifle, a long rifle, a shotgun, a handgun, any of these firearms are arms under the text of the right of the people to keep and bear arms shall not be infringed. That's a no-brainer. And yet that has to be resolved yet again, because some of these courts play games talking about, well, you also have to look at all these other things. That is clearly not true, but we'll get to that in 1 second. Now, of course, the question is there some sort of a hindrance or infringement or some other thing that is restricting, meaning the government is doing some restriction on the conduct of the rights claimant here? In this case, is a criminal defendant who was indicted and charged with possessing an unregistered short barrel rifle. In a civil lawsuit, that would be, I want to possess a short barrel rifle and not pay the tax or register the gun, and thus my Second Amendment rights are being violated by the government law. Whatever way you want to approach it, the question is whether or not there's some sort of a hindrance to your proposed possession of the short barrel rifle. And because there is clearly a hindrance, that means that the text of the Second Amendment has been implicated by this government law, the National Firearms Act. And once the text is implicated, once the conduct of the individual rights claimant, in this case, Mr. Rush, has somehow been implicated by the text of the Second Amendment and vice versa, it means that the particular law in play in this case, in this context, essentially the de facto taxation registration scheme under the National Firearms Act of short barrel rifles, that is presumptively unconstitutional and illegal and unenforceable. That is the presumption. At that point, the burden shifts to the government to show that there is an exception, a historical exception, to the clear and unqualified command of the text of the Second Amendment. And that exception can be demonstrated by only one way. It cannot be demonstrated by interest balancing. It cannot be demonstrated by weighing the good and the bad of guns or anything like that. It has to be demonstrated using a historical tradition, and not just any historical tradition. In other words, it doesn't matter that, the type of underwear that Abraham Lincoln wore. It doesn't matter, what Shakespeare meant. No, none of that history is relevant to this inquiry. The specific history is, was there a historical tradition of firearms laws and regulations? It's a particular type of history specific to what lawyers do, which is to look at historical laws, and that is the question. Is there a historical tradition of firearms laws and regulations that would somehow justify this ban, if you will, on unregistered short barrel rifles. And if you look specifically at this situation, it is pretty clear that our side should win, because now that the burden shifts to the government, the burden is on them to show there's a historical tradition of some sort of ban or restriction on unregistered short barrel rifles, and that's clearly not the case. And what's quite interesting, and this is very interesting and very good for our side, is that you may recall, and this is how it all connects up. Remember, I teach you all these videos and all these things I talk about all connect up. You know, you got to understand where all the dots connect up. A few months ago, we talked about that United States versus Peterson case down there in the U.S. Court of Appeals for the Fifth Circuit out of Texas and Louisiana and Mississippi. And you may recall the Peterson case deals with another national firearms issue, which is whether or not suppressors are protected arms. And what's quite interesting there is that the Donald Trump Department of Justice, which is the most pro-Second Amendment administration in American history, is my view, and I stand by that, they put in a very powerful statement in the Peterson case dealing with the protection of firearms involving the NFA and the Second Amendment and the like. And let me read to you specifically what the Trump administration submitted in that Peterson case, and I suspect we may see this kind of language come back at us in a favorable way in this case of Rush versus the United States. And you'll see how it all gets connected up, and all these different things we cover all get brought together, and often in a very favorable way. Here's what the DOJ had to say just a couple months ago on behalf of the Trump administration involving suppressors and the National Firearms Act and how it connects up the rifles. Because ordinary firearms, unlike suppressors, are not peculiarly susceptible to criminal misuse, registration laws or taxes targeting such firearms likely would not serve or be proportionate to any legitimate public policy purpose. And they cite to Brett Kavanaugh, then Judge Brett Kavanaugh in 2011 when he was on the D.C. Court of Appeals, who said, quote, requiring registration of individual guns generally does not serve any legitimate purpose and is usually aimed at deterring gun ownership. The Trump administration then goes on to say, in addition, a law regulating or taxing the firearm itself would impose a more severe burden on the right to keep and bear arms than regulations on useful but non-essential accessories such as suppressors. So that's quite interesting. Now, set aside my views as to whether or not the DOJ got that statement right about suppressors. They specifically said that if you're dealing with an unregistered, untaxed firearm, that really does give rise to a serious Second Amendment question that may not be presented in the context of suppressor regulation. So it's going to be very interesting to see if that is fully developed in favor of us, because I think there's a very good chance that the Department of Justice may actually come out and agree that the Second Amendment is violated in this particular case. We will see very soon. But let's carry on. The other interesting thing, of course, is that the NRA brief, which I think does a good job flagging some other issues that the Department of Justice is going to have to address. The first thing, of course, is what is an arm, and are all firearms arms? And the answer is going to be undeniably yes. I think only the lower courts that want to play games with this are not serious, and the Supreme Court won't take them seriously because firearms are undeniably at the textual level arms. Then there is this question about in common use. And this is not rocket science, and this is also very straightforward. You on the Four Boxes Diner understand this. It's quite clear. Let me be clear, so we're all on the same page. Textually, analyzing the words of the Second Amendment is a semantic or a linguistic exercise. What do those words mean in 1791 when they were written? What was the original public understanding of the words as a matter of linguistics, as a matter of semantics, just language-wise, which is why the Supreme Court uses dictionaries at the time to define the words and the phrases. Once you do it that way, the burden shifts to the government. Once it's implicated, right? The law implicates the Second Amendment. We've talked about this. The burden shifts to the government. And then you engage in the historical analysis. Now, if you look at the Supreme Court case of U.S. versus Miller in the 1930s and the Heller case that relied on Miller, they make it very clear that the one thing that cannot be banned are arms that are in common use by Americans for lawful purposes. And the reason why you cannot regulate, you cannot ban them, you cannot tax them, because they're protected arms undeniably, is arms that are in common use by Americans for lawful purposes, because those are arms that are not dangerous and unusual. Now, here's the critical thing and why they're games played. And I've written about this in the Harvard Journal of Law and Public Policy. You guys have all probably read the article. It's cited everywhere. And that's this. The in common use test derives from the historical tradition of firearms regulation, meaning that you can ban or restrict or regulate the carrying of dangerous and unusual arms. That analysis derives from a historical tradition of firearms regulation. And since you're talking about a historical tradition of firearms regulation, you're at the historical level of the Bruin methodology of text first and then historical regulation analysis second. And because you're at the historical tradition level of the analysis in the Bruin text first, then history second, what does that mean? You know what it means. The burden is on the government. The burden is on the government to prove that there is a historical exception to the text's unqualified command there in the Second Amendment. Which means the burden is on the government to show that the arm they're trying to tax, that the arm they're trying to ban, that the arm they're trying to insist be registered, they have to prove that that arm can be banned or regulated or taxed by virtue of showing that the particular arm they're regulating or banning is not in common use. Because if it's in common use, it cannot be dangerous and unusual. The burden is on the government to show that an arm they're regulating is dangerous and unusual, which means they bear the burden to show that the arm is not in common use. This all occurs at the historical level where the burden is on the government to demonstrate and justify an exception, if you will, to the text of the Second Amendment. So those courts that try to elevate the in common use test to the textual level are playing a game to throw the Second Amendment under the bus. Because what they're trying to do here is to say that you elevate in common use to the textual level and you shift the burden onto the Second Amendment rights claimants to the Second Amendment side and away from the government. But you're not allowed to do that because the in common use test derives itself from history. And when you're talking history, the burden is on the government and not on the Second Amendment rights claimant. So that is something the Supreme Court's going to have to clear up. And the NRA brief here in the Rush case makes that exact point. Some of the other issues here that they discussed is to what constitutes in common use. I think that's pretty much straightforward. Certainly something that is owned over 500,000 of them, which is the number of short barrel rifles registered on the NFA. That's clearly in common use. Keep in mind that there was 200,000 stun guns in Caetano, and that was basically indicative of common use, and 500,000 short barrel rifles is in excess of 200,000 stun guns we saw in the Supreme Court decision in Caetano and the opinion of the concurring opinion, I should say, of Justice Alito in that case. Also, there's a discussion of what is useful in military service. This is really a red herring. It doesn't matter whether or not a gun is useful in military service or not, because obviously semi-automatic handguns are undeniably useful in military service because basically every soldier carries, among other things, a semi-automatic handgun. Those were protected arms under Heller. But again, there may be other weapons that are useful in military service like nuclear arms or cannon or whatever it is. They would not be protected under the Second Amendment in today's reality with the current Supreme Court. So being related to military service doesn't really tell us much when it comes to assessing whether or not an arm is dangerous and unusual. And there's some other critical things here, but the most important thing to understand is what is the Trump administration going to do in this case? They're going to have to file a brief, and I think it's going to be very favorable because if you look at what they said in the brief they submitted in the Peterson case dealing with suppressors, and if you look at what the Department of Justice under Donald Trump submitted in that Barnett case out of the U.S. Court of Appeals for the Seventh Circuit, which is going to get argued, I think, in September, they said very favorable things about how to analyze what arms are protected under the Second Amendment, and I think that we're going to see a very similar favorable brief to the Second Amendment submitted to the U.S. Supreme Court by the Trump administration between now and the start of September, unless maybe they'll get an extension of 30 days or something like that. We'll see. Anyway, there you have it, folks. Big news today out of the Supreme Court. Let's see what happens. Be very interesting to see what the Trump administration does. I'm optimistic it's going to be a good brief in our favor, but only time will tell because the history of the future has yet to be written. So there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.